Hello friends, welcome back. Today we're discussing a landmark judgment of the Supreme Court of India titled L. Chandra Kumar versus the Union of India and others. The matter was decided on 2nd of December 1994 by Honorable Justices Kuldip Singh, B. L. Hansaria and S. B. Majumdar Justices. The matter pertains to the Constitution of India, Articles 324A and 324B, Administrative Tribunals Act 1985, Section 5, Subclause 6, constitutional validity thereof, matters arising out of judgment of Constitutional Bench in SP Sampath Kumar versus Union of India, and subsequent decisions referred to the larger bench. In a matter involving an examination of Section 5, Subclause 6 of the Administrative Tribunals Act 1985, this court was confronted with wider issues relating to the composition, jurisdiction, power, and authority of tribunals constituted under Articles 324A and 324B. Referring the matter to a larger bench, this court held, in view of the decision in SP Sampath Kumar's case, by which a constitution bench of this court decided the wires of the Administrative Tribunals Act 1985 and observations made therein, the matter to be placed before a larger bench for reconsideration. Subsequent decisions on matters adjudicated upon in Sampath Kumar are also referred to the larger bench. The issues referred to the larger bench include: first, whether tribunals can be equated with high courts; second, the jurisdiction, power, and authority of administrative tribunals to adjudicate upon questions of constitutional validity of legislations and of rules; third, whether a tribunal which has the power to decide on the constitutional validity of a statute or rule made under Article 309 can have an administrative member on its bench; fourth, whether the power of judicial review held to be available to administrative tribunals as per Sampath Kumar's case violates the basic structure of the Constitution. Cases referred to are SP Sampath Kumar versus Union of India, JB Chopra versus Union of India, Amulya Chandra Kalita versus Union of India, Mahabal Ram versus Indian Council of Agricultural Research, Sakinala Harinath versus Andhra Pradesh, MB Majumdar versus Union of India, State of Orissa versus Bhagwan Sarangi, RK Jain versus Union of India. The following order of the court was delivered. The challenge to the validity of Section 5, Subclause 6 of the Administrative Tribunals Act 1985 has unmasked greater issues to examine which we have come to the conclusion that the judgment of this court in SP Sampath Kumar versus Union of India, which is by a constitution bench of 5 learned judges, needs to be reconsidered by a larger bench. Our reasons follow. The Constitution 42nd Amendment Act 1976 inserted Part 14A in the Constitution, which contains Articles 323A and 323B. These articles conceive of setting up of various tribunals as adjudicatory bodies. They inter alia contain provisions which enable not only the Parliament but even state legislatures to exclude the jurisdictions of all courts except that of this court under Article 136 with respect to matters falling within the jurisdiction of the concerned tribunals. The Act came to be enacted by the Parliament in exercise of the powers conferred on it by Article 323A of the Constitution. The wires of the Act was challenged before this court, which was upheld in Sampath Kumar's case. While upholding the validity of Section 28 of the Act in Sampath Kumar's case, this court took the view that the power of judicial review need not always be exercised by regular courts, and the same can be exercised by an equally efficacious alternative mechanism. Apart from making suggestions relating to the eligibility, etc., of the persons who could be appointed as chairman, vice chairman, or members of the tribunals, this court stated that every bench of the tribunal should consist of one judicial member and one administrative member. The primary reason, according to us, for having a fresh look at the issues involved in Sampath Kumar's case is the observations of the bench therein, by which the tribunals have been equated with the high courts. A two-judge bench of this court in JB Chopra versus Union of India relying upon Sampath Kumar, has held that tribunals have the jurisdiction, power, and authority even to adjudicate upon questions pertaining to the constitutional validity or otherwise of a rule framed by a President of India under provisions to Article 309 of the Constitution. They can even adjudicate on the wires of the acts of the Parliament and state legislature. Section 5 subclause 6 of the Act gives this power if the chairman of the tribunal so desires, even to a single administrative member. It is a different matter that no chairman would like to do so, but that has no relevance while examining the validity of the subsection, which reads as below. Notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers, and authority of the tribunal in respect of such classes of cases or such matters pertaining to such classes of cases as the chairman may by general or special order specify, provided that if at any stage of the hearing of any such case or matter it appears to the chairman or such member that the case or matter is of such a nature that it ought to be heard by a bench consisting of two members, the case or matter may be transferred by the chairman, or, as the case may be, referred to him for transfer to such bench as the chairman may deem fit. In Amulya Chandra Kalita versus Union of India, a two-judge bench of this court held that the administrative member of tribunal alone is not competent to hear and decide a case. This view was taken after referring to what has been pointed out in Sampath Kumar's case, requiring bench of the tribunal to consist of one judicial member and one administrative member, following which observation the Act was amended to say so, vide its Section 5 subclause 2 as substituted by Act 19 of 1986. The attention of the bench deciding Amulya Chandra Kalita's case, however, was not invited to Section 5 subclause 6. This aforesaid point came to be examined again, and this time a three-judge bench in Dr. Mahabal Ram versus Indian Council of Agricultural Research. When the attention of this bench was drawn to Section 5 subclause 6 of the Act, it opined that any matter involving questions of law or interpretation of constitutional provisions should be assigned to a two-member bench, and parties can request the single member to refer the matter to a larger bench of two members, and such requests should ordinarily be accepted. In pursuant to these observations, an order was passed by the chairman of the Central Administrative Tribunal on December 18, 1991, which is in consonance with the same. It deserves notice that in Mahabal Ram's case, there was no challenge to the validity of subsection 6, but the same has been assailed here. Shriram Joyce, in assailing the validity of subsection 6, has raised larger issues before us, one of which relates to the view taken in Sampath Kumar's case that judicial power need not always be exercised by regular courts. According to the learned counsel, this is contrary to the diktat laid down even in Keshwanand Bharti versus State of Kerala. Indeed, this is a view which has been taken recently by a full bench of Andhra Pradesh High Court in Sakinala Harinath versus State of Andhra Pradesh. For the sake of completeness, it may be mentioned that the decision in Sakinala has been assailed before this court in CA number 169 of 94, which has been referred to a constitution bench. Another facet of the case focused by Shriram Joyce relates to the equality of status between tribunals and high courts. A note discordant to that of Sampath Kumar was struck in this regard by a three-judge bench of this court in M.B. Majmudar versus Union of India, holding that administrative tribunals cannot be equated with high courts in all respect as they are not deemed high courts, because of which members of tribunals cannot claim equality with high court judges as regards pay and age of superannuation. Mention may also be made about the view taken by this court in State of Orissa versus Bhagwan Sarangi, that a tribunal established under the Act is nonetheless a tribunal and it cannot sidetrack a decision of the concerned High Court. It would not be out of place to refer to a three-judge bench decision of this court in R.K. Jain versus Union of India, in which need for the members of the tribunal in brackets, which was Seagate in that case, set up with the aid of Article 323B, but what has stated therein would apply proprio vigore to the tribunal at hand. Having adequate legal expertise, judicial experience, and legal training was emphasized to enable the tribunal to become effective alternative institutional mechanism and to dispense with the High Court's power of judicial review. Ramaswamy J, however, opined that such tribunals, being creatures of statute, can in no case claim the status of High Court or parity or as substitutes. The aforesaid post-Sampath Kumar cases do require, in our considered view, a fresh look by a larger bench over all the issues adjudicated by this court in Sampath Kumar's case, including the question whether the tribunal can at all have an administrative member on its bench. It were to have the power of even deciding constitutional validity of a statute or 309 rule as conceded in Chopra's case. Examination of this aspect would be necessary to instill confidence in the minds of people and litigants, which is the greatest prop of the judiciary. Let the records be placed before the Honorable Chief Justice of India for constitution of an appropriate bench.